Welcome everyone to another Field Fisher webinar. My name is Hazel Grant and I am the Head of Privacy at Field Fisher and your chairman for today's session. Today's topic is nefarious liability, dealing with the insider threat following the Morrisons decision. So the topic is the Morrisons decision, but it's not as you know it. We're not picking over the legal ins and outs and arguments. Instead, we want to look at how employers should respond. What are the practical steps that we should all be taking as employers right now? So I'm joined this afternoon by two colleagues to help cover these points. And I'm going to ask them both to introduce themselves right now. So James Seadon is a partner in our dispute resolution team. So James, could you say a few words, please?
Thank you, Hazel, and hello, everybody. I'm James Seadon. I lead Field Fisher's data disputes practice, and for over a decade, I've been helping our clients with contentious privacy and data protection matters, ranging from litigation between corporates, for example, data controllers pursuing contractual and tortious remedies against failing processors, to disputes between controllers and data subjects or coordinated groups of data subjects. And I also advise our clients on intellectual property matters like brand protection and the theft of trade secrets, as well as handling cybersecurity work, which includes incident readiness and remediation, but most frequently is at the sharp end of incident response and crisis management.
Thanks very much, James. And next, let's turn to David. David Lorimer is a director in our employment group. David, could you introduce yourself, please?
Thank you, Hazel, and hi, everyone. Yes, I sit in the Employment, Pensions, Immigration and Compliance team, or Team EPIC, as we like to be called. I specialise in the overlap between employment and privacy. I spend much of my time advising on insider threats, the HR implications of data breaches, employee monitoring tools, investigations, background checks, and unfortunately DSARs. So that means I've spent years following this case, but I'm not always popular at a dinner party.
Thank you, David. So just to say, everyone, we will leave time at the end for questions, so please do add them into the platform in the questions function. We'll also send a recording of the session today and send the slides afterwards so that you will have those to refer to, so please don't feel you have to scribble too many notes. So let's take a look at what we're going to cover this afternoon. Having told you that we weren't going to pick over the legal ins and outs, I feel an obligation to give you a bit of an overview of the Morrisons decision and how we got to where we are right now. I then want to raise a particular data privacy issue, which is the importance of having appropriate security measures in place, which is one of the key things which I personally feel, and I think others in our team feel as well, has been missed from some of the commentary on the decision. We're then going to turn to James, who will talk to us about the risk profile of privacy disputes following Morrisons. And then last but certainly not least, we're going to turn to David, who's going to take us through the key implications for employers and the practical actions that employers should be taking. So let's get on to the facts, shall we? A brief reminder of the facts and the outcome at each stage of this decision. Mr. Skelton was employed as an internal auditor by Morrisons. He had a job to do, and that included handing some information on a large number of employees at Morrisons, over 100,000, to KPMG, who were the external auditors. In 2014, he had been subjected the previous year to a disciplinary sanction, and he held a grudge against Morrisons. As a result of that grudge, he sought to exact some revenge by taking a copy of the data on his colleagues and publishing it. He put it on a website when nobody was really noticing it. He then highlighted 3 newspapers that this website existed and the data was on it on the day that Morrisons was publishing its results. Somewhat interestingly, as a bit of an aside, the case reports all refer to the white powder incident, which had been the cause of the disciplinary sanction for Mr. Skelton. He ran a little side business where he was selling a slimming product, and occasionally he would package it up and send it through the post room at Morrisons. He was not using them to pay for the postage, but he was using their facility to post it. One of the packages broke open in the post room, and this led to white powder going over everybody and not anyone knowing what was in the powder. And he received some disciplinary sanction, which he felt was excessive. Anyway, Mr. Skelton was charged with offences under the Computer Misuse Act, fraud, and Section 55 of the Data Protection Act 1998. As a result of those, he was jailed for 8 years. Then we find that eventually over 9,000 staff members pursued a group legal action against Morrison to recover damages for the distress caused by their payroll data being published. Their payroll data obviously including name, date of birth, bank details, and how much they were being paid. So what happened in the cases? So in the first hearing, it was decided that there was no direct liability on the part of Morrisons under the Data Protection Act 1998. Various principles had been breached by Mr. Skelton because he had taken a copy of the database and published it when he should not have done so. But curiously, it was decided that Morrisons had not breached the 7th data protection principle, that of adequate security. The court then went on to consider vicarious liability, and it was decided that it was possible for vicarious liability to exist alongside the Data Protection Act 1998. So a claim had been raised that perhaps these two could not coexist, but that was rejected. And it was held that Morrisons was vicariously liable for the actions of Mr. Skelton. This was then appealed to the Court of Appeal. At the Court of Appeal, again, there was a lot of discussion of the statutory interpretation about whether or not the Data Protection Act could coexist with vicarious liability, and it was decided that the DPA does not exclude vicarious liability. It was decided that the High Court decision should be upheld, that Morrisons were vicariously liable, and that was because the acts were within the field of activities, that there was an unbroken chain between the actions that were carried out. And referring back to some previous cases on vicarious liability, reference was made to the fact that the motive of Mr. Skelton was irrelevant. However, then we come to the Supreme Court. At last, you might say, as far as Morrisons were concerned, success. The Supreme Court upheld Morrisons' appeal. So Morrisons are no longer vicariously liable. The key factors were that the Court of Appeal had incorrectly interpreted some previous case law. It was not an act that Mr. Skelton was authorised to do. Simply saying that Mr. Skelton was authorised to handle data did not mean that he was authorised to go and publish data in this fashion. And the fact that there was a mere causal or temporal connection was not sufficient. So what you had to look at is whether the wrongful act was closely connected to what the employee is authorised to do. And in this case, he wasn't authorised to do this. And interestingly, the Supreme Court then went on to say that motive itself may well be relevant, and that the previous courts had actually misunderstood that. And obviously here, Mr. Skelton's motive was to harm his employer. So it seemed a little ironic to make his employer vicariously liable. So where does this leave this? Well, before I hand over to my colleagues, I wanted to pick up on a topic that I mentioned a few moments ago, and that is the importance of having appropriate security measures as an employer. So I do find it slightly curious that Morrisons managed to avoid any direct liability under the Data Protection Act 1998, obviously appreciating that we are now in 2020 and the facts in this case were in 2013, 2014. However, what had happened was that Mr. Skelton had been able to take a personal USB stick and use that to download the data relating to his fellow colleagues, which seems a little curious, I'm sure, to many of us now, because we will all be well used to the sort of restrictions that exist to prevent people putting USB sticks in laptops and just taking large downloads of data. So I think that employers would be well advised to pay particular attention to this obligation, the requirement for appropriate security measures as set out under the GDPR. I won't read through this now, but as you can see, it is broadly related to what existed under the Data Protection Act 1998, but it expands upon it now. It gives it a little more flesh as to what the ins and outs are and what the relevant factors might be and the sorts of actions that we should be considering in order to ensure that we have appropriate security. So I think it's important to say that those points need to be borne in mind and that employers need to recognise that they have to have appropriate security. Now, having said that this fleshes out what the requirement is for appropriate security, it is, I'll be truthful, a little vague. So given the black letter law can be so vague, what other guidance might exist out there to help employers? Well, we can turn to what our regulator, the Information Commissioner's Office, says. And here the ICO makes it clear that not one size fits all. You have to assess what is appropriate to you. You have to look at organisational and technical measures in order to protect the data that you are looking to protect. Occasionally you will find that the ICO can be more direct in their guidance. For example, some of you may remember the ICO issuing guidance quite a few years ago now saying that movable media, those USB sticks, should be encrypted. And indeed, if you go onto the ICO's website now, you will find that beyond this, they do point you to a number of different standards and guidance that has been issued by certain bodies such as government bodies helping you counter crime and cyber issues. Now, another thing that the GDPR also recognises is the possibility that there could be some standards that could perhaps migrate into certifications and codes. So it is important to look at useful standards that may exist elsewhere as well. We've just left here a smattering of the numbers that can exist, but you will probably be aware that in the GDPR, there is a reference to the fact that certifications and codes can help show appropriate security. So they're not guaranteed that they will give you appropriate security, but they will contribute towards it. We don't have any certifications or codes approved as such, but you could imagine that they might be based upon these types of standards. So at this point, I will pause and hand over to James, who is going to look at the status of privacy disputes post Morrisons.
Thanks, Hazel. So, by way of context, we will take a look at some common types of privacy disputes, as well as the trends that we've been seeing in recent years. And as a spoiler alert, there's more litigation than there used to be, and there will be more in future. I'll then focus the spotlight on collective actions, as that's a direction of travel that is well worth being prepared for. And I'll explain exactly why disputes matter so much in privacy and how in the worst case scenario, litigation could pose an even greater threat to your bottom line, arguably, than the eye-watering GDPR fines that grabbed everybody's attention a few years ago. And we'll then look at exactly what the Supreme Court's recent decision in Morrisons, as Hazel's just been explaining, is likely to mean for disputes in the privacy world in the medium term and beyond. So moving on to my first substantive slide, what sorts of things do I mean when I say privacy disputes? Well, there's different ways we could categorize privacy disputes. We could look, for example, at the underlying causes of action. So we could categorize things as disputes arising under the GDPR or the Data Protection Act 2018. We could box off disputes where, like in Morrisons, the old 1998 Act still mattered. And while we're on the subject, it's worth bearing in mind that while contract claims in English law are time barred 6 years after a breach, the limitation period for statutory torts runs from when the damage accrues. So in cases of latent damage from data breaches, the old law could be relevant for some time yet. Don't put your books away. There are disputes arising under the e-privacy framework, and perhaps some of you will have tackled claims from individuals wanting compensation for marketing emails said to have been sent in breach of the privacy and electronic communications regulations, and there's claims in contract whether the contract being sued upon is your consumer terms or a data processing agreement, and in tort, such as for negligence. Alternatively, we could look at scope of disputes. Some disputes are narrow and concern, for example, one counterparty, perhaps a single aggrieved data subject, but others, and often those arising from data security incidents, can be truly multinational. We regularly help clients to coordinate their strategies across jurisdictions. But I think a more helpful way to visualize data disputes may be to look at the counterparty, as you see on this slide. And first, we have the issues with threat actors. These are the bad guys. Your average data controller, even with the best technical investigation in the world, probably isn't going to want to pick too many fights with a state-sponsored APT, the advanced threat actor that you might have read of, and many hackers go beyond the reach of civil litigation as well. The focus is more likely to be on damage limitation, mitigation, and remediation. But there are other bad actors who are much less remote, the principal category of these being the insider threat, whether that means bad leaver employees who are merrily setting up a competing business with your data, or even disgruntled current employees who resort to criminal acts, as Mr. Skelton did at Morrisons. David will have much more to say about these threats, but the latter category often leads to civil litigation as well as criminal investigations. Second, and I'm sure this doesn't apply to any of the organisations represented by those watching today, businesses do from time to time find that their view of the world differs from that of the regulator, and in sharpest focus, this might mean things like appeals against fines and other enforcement action. For example, I've contested not only financial penalties levelled by the Information Commissioner, but also challenged whether enforcement notices should have been made in the first place. Third, and not at all infrequently, we have disputes between data controllers and their data processors. Some of those will be mundane contract disputes around termination or money or whatever, but others, and those that have greater privacy implications, include those where performance of the contract has perhaps been so abject that serious damage has resulted. Once, for example, I represented a client in litigation against a secure waste processor that was engaged to destroy legacy computer equipment, including hard drives, but where some devices had slipped through the net and were sold on eBay. You can understand why the client was not best pleased and called on our help. Fourth, we have disputes between data controllers and data subjects. These fall into many of the categories I mentioned earlier. PECA claims about marketing emails, for example. They might include data subject access requests made in acrimonious circumstances, such as those used as weapons in other litigation. And topically, for today, they include claims for compensation in the wake of data breaches. And there's a fifth category on the slide where, again, David will have much to say, disputes with employees. Of course, in one sense, these are a special category of data subjects where the relationship is different from that between business and consumer, but they're also prospective bad actors. I'm not suggesting you should adopt too paranoid approaches, but business must appreciate this risk. Now, in terms of the trends that we've been seeing in recent years, I first got properly involved in data protection work about 15 years ago when I was working as in-house counsel to a multinational telco. Data protection was tacked onto my IP and tech remit, probably because it was the best fit, but let's be honest, back then the rest of the team weren't falling over themselves to volunteer either. Many people thought data protection law was fairly dull compliance work, and they were wrong, of course, as those of you of similar or even finer vintages to me will no doubt be screaming into our comments box right now. But times have changed, people's perceptions have changed with them, and part of the evolution of privacy law is that we're seeing more disputes in general. What I'm not talking about is the gripe that is occasionally aired in the UK that as a society, we're becoming a society driven by litigation. There might be a degree of that, but to my mind, what's really driving the change in privacy law is all part of the transformation that was wrapped up in GDPR, and underlying those reforms were concepts of stronger rights in data, greater transparency, greater accountability. The increased transparency means first and foremost that data subjects these days are better informed in relation to their rights in general, further encouraged by consumer representatives and activists, and of what's been happening with their data. It's less likely these days that a data subject will be blissfully unaware that personal data has been stolen and sold online. And then stronger rights and greater accountability have created a framework within which data subjects can bring claims more easily, more effectively. For obvious reasons, this leads to more interest in litigation and ultimately more litigation. There's a further backdrop, which is that the new world of data litigation is also leading to interest in business models inherited from elsewhere. So litigation funding, for example, is part of the explanation for a third trend, which is a rise in collective action. One of the key factors in Morrisons was the number of claimants, almost 9,000 or almost 10,000, I think, by the time the Supreme Court heard the action, out of a pool of almost 100,000 employees had been affected in the outset. And so instead of claims by solo data subjects, controllers now face the risk of coordinated claims by many. And collective actions matter. By now, you'll probably have a pretty good sense of what the worst case GDPR fines, 4% of your annual worldwide turnover, would look like for your organization, and plainly we all hope you never find out for real. Those prospective fines caught the attention of C-suite executives everywhere. Data protection and privacy law is a board level issue on par with competition law and other business risks. But what's often overlooked is that a serious data security incident might have consequences beyond a fine. First of those being reputational harm, which is beyond the scope of today's webinar, but shouldn't be discounted. And the key second one is the financial cost of possible litigation. Collective actions in particular, or even many thousands of individual claims, there are large aggregate costs to think about. Part of this is the cost of simply contesting all of those disputes. But if you think about a data breach affecting 1 million data subjects, which a few years ago would have been enormous, but these days is becoming more and more common. And if you apply a very broad brush and say each data subject might be entitled to £1,000 in damages, which is not overly generous, then you're looking at a potential aggregate liability of £1 billion, and that's for a business of any size. This does matter. There are different ways in which collective actions can be brought in the English courts, and the two principal ones are group litigation orders and representative actions. Now, Morrisons was an example of a group litigation order. This is a mechanism that's been around for a little while, where the courts can combine the claims of claimants with similar circumstances. They have to share common related issues of fact or law, and basically you bring a claim, you sign up to a register to be dealt with as part of a group. Importantly, this is an opt-in mechanism. Morrisons has been the test case for it, as it were, in the privacy sphere, although we've seen that in the BA, British Airways group litigation, that is also being run now as a GLO, interestingly prompted by BA rather than by the claimants. But what happens is the courts determine a GLO issue, which is basically any issue which applies commonly amongst the pool of claimants, and then that's binding on everyone. There will be non-GLO issues as well. So these will typically include how much damage everyone suffered and therefore what compensation they're entitled to. That has to be determined outside the group action and individually for each claimant. But the mechanism works pretty well for claims where you have liability on identical facts, but individual quantum. So a data breach leading to distress, where some people will be much more distressed than others, presents this sort of consequence. The alternative mechanism is the representative action, which is brought under our civil procedure rules in 19.6 in particular. Traditionally, the English courts haven't really wanted this to allow true class actions, but there's increasing talk of a move towards the US style class action. Representative actions are pretty rare, but we have seen two brought in the privacy sphere in recent years, one in the case of Lloyd against Google, another against Equifax, although that's appears to be being pulled in recent weeks. Representative actions, you need, again, claimants with common interest. Anyone can start a representative action. You must seek remedies which benefit all members of the class. So the key thing in the Lloyd and Google litigation is that they are looking for effectively fixed damages for the loss of control of private information, rather than anything that might vary between claimants, like distress. There are other models for collective actions as well. The GDPR contemplates some in Article 80, and other European jurisdictions have brought in laws that allow sort of collective representation as well. But the group litigation order and the representative action is what matters here in England. Moving on to what Morrisons means for disputes in light of the Supreme Court's decision. Plainly, things went better in the Supreme Court for data controllers than they did in the Court of Appeal. It couldn't be said that this was a disaster. The key point, or one of the key points, is that the Supreme Court has narrowed the circumstances in which businesses might face vicarious liability. Perhaps better expressed, the courts confirmed that previous decisions weren't quite as bad as people feared after the Court of Appeal. But this doesn't necessarily matter that much. Again, as David might explain in more detail, direct liability is more likely in the wake of a data security incident or another privacy wrong than vicarious liability. It's pretty unusual circumstances where you need to fall back on vicarious liability for a claimant to get home. So this doesn't affect that, and in a sense, Morrisons is confined on its facts, and it's premature to celebrate any substantial change. Importantly, although this is a bit of a blow to the growing concept of the collective action in privacy law in the English courts, I don't think it's going to dampen things too much. We've seen a group of almost 10,000 claimants successfully litigate against the supermarket Morrisons all the way to the Supreme Court. Even though they didn't get the outcome they wanted, the mechanisms worked. They've fought the litigation successfully and caused a real headache for their opponent. And collective actions will continue, both GLOs, as we will see with the British Airways group litigation ongoing, and also the representative action. And the key example of that, as I've been saying, is Lloyd and Google. I think what's really important is that Lloyd and Google is currently destined for the Supreme Court. It will probably not be heard until 2021, and it's only in truth looking at preliminary matters, but we're expecting to learn a lot from the Supreme Court. Not only will we hear whether Mr. Lloyd's representative claim satisfies criteria for service out on Google, and thus whether that litigation can continue, but also in terms of how damages might be assessed in such cases. The case may look at damages for the loss of control of personal data. It might even touch on a concept of user damages, which has been floated in earlier hearings. That all will inform the current moves towards bringing these group claims, and therefore the growing risk profile for data controllers, because of course organized, coordinated data subjects have much more power and much more collective funding than an individual. And so where strategies might be to pick off one or two data subjects who have claims in the past, that's increasingly difficult where they organize together in very large numbers. And on that note, I think I can hand back to Hazel and David.
Thanks very much, James. So let's now turn to our final speaker, David, who is going to take us through the key implications and actions for employers. David, over to you.
Yeah, thank you very much, Hazel and James. Really interesting analysis. As kind of trailed, I'd like to spend a little bit of time looking at what this case and actually one other that's handed down on the same day means for employers when it comes to their vicarious liability, or the extent of that for the acts of their employees, before looking more broadly at what practical steps employers can take to mitigate the data security risk that's caused by or represented by their employees, i.e. the insider threat. And we're going to look more broadly at that actually, and not just focusing on where an employee, as Mr. Skelton was, is hell-bent on pursuing a vendetta, which is hopefully a vanishingly small number of your employees or none. So starting with vicarious liability. There were in fact 2 Supreme Court judgments on the extent of an employer's vicarious liability for acts of its personnel on one day. I'm sure there's a joke in there about waiting years for the man on the Clapham omnibus to turn up, but it's too geeky even for me. Both cases, I think, broadly seen as good news for employers, and rightly so, and James has touched on that. Starting with Morrisons, overall, the Supreme Court essentially reiterated that there needs to be a kind of sufficient connection between the position in which the employee was employed and their wrongful conduct for the employer to be liable. Now, obviously, the gap between an employee who is off on a frolic of their own, and by the court's language, outside of employer liability, and where there is enough of a connection to employment, is a really broad one. And it had meant that employers struggled to identify what they were indirectly responsible for historically. In looking more closely at what that connection should look like or needs to look like, the Supreme Court has made the position clearer and overall more favourable for employers. So the judgment itself touched on a broad range of factors, and there was lots of interesting legal analysis in there, but I really want to focus on 2 key takeaways before getting on to the practical steps. So firstly, they look closely at the field of activities. And just to explain that a little more, even though Mr. Skelton's job gave him access to the payroll data of 126,000 employees, i.e. the opportunity to cause damage, the fact that he abused his position of trust wasn't, it would seem obviously, within the course of his employment. So publishing the data wasn't within his field of activities in the way that he did. So essentially there were kind of 2 stages. One, did he have access to the data and an opportunity in the course of his duties? Yes. But fortunately, the Supreme Court went further and said, was causing that breach in the field of those activities? And the answer to that was no. So actually, previously, the courts would look more widely at whether there was an access and opportunity through employment generally. So narrowing the scope there is good news. On practical takeaways, we're going to come back to this shortly, but I think the obvious one from that is properly scoping roles, responsibilities, and authorities, although it can be nightmarish and drafting job descriptions isn't the most interesting thing in the world, it would seem to reiterate that that's a good idea. Then the court went on to look at the motive of the employee, which again was quite interesting. So they said that for vicarious liability to exist, the employee's motive behind the action they've taken needs to be to further the employer's business and shouldn't, importantly, be a personal vendetta. So motive is relevant. Again, that's good news for employers who are now less likely to be found indirectly or vicariously liable for rogue employees who've gone out of their way to damage them. But as James has already mentioned, the facts of Morrisons were quite extreme. We'd hope that they're unlikely to be repeated very often in the workplace. So there's still quite a big question mark, I'd say, around how relevant motive is, especially in circumstances where motive behind this kind of action or consequence is much more likely to be either unclear or mixed. So in Morrisons, we had the benefit of a criminal decision, and that sort of very clearly indicated that there'd been a desire to take down Morrisons by whatever route necessary. That's not going to exist in many cases, and so yes, we should look at motive, but I guess I would urge caution, and that's actually borne out by a couple of other judgments on this when it comes to liability for other kind of physical harms caused by employees, where it's really not clear where a bad personal motive starts and a bad professional motive ends, as it were. I also, just before we move on, wanted to really briefly mention the second vicarious liability judgment handed down on the same day. So that's Barclays, that's set out on the slide. And in that, some medical examinations were carried out on behalf of Barclays to produce health reports for candidates for employment. The doctor who carried those out was accused of sexually assaulting a number of the candidates. And in that case, the Supreme Court again held that there was no vicarious liability for Barclays. In this instance, it was because he was an independent contractor. So there was a genuine arm's length commercial arrangement. Now, that does suggest that independent contractors or genuine consultants, as they might be called, including kind of software development, information architecture, and in the tech sector, which is rife, might not give rise to vicarious liability. But it's, again, there's a slight caveat around that, in that a court will look beyond what the contract says. So contracts for these people will hold them out as genuinely self-employed, but the reality of the relationship might not reflect that. And if, in looking into the reality of the relationship, the court decides that it's more like an employment or worker relationship, then again, vicarious liability is live. Next slide, please. So getting on to practical steps, and I think what's really important to frame this is that Morrisons was really interesting, both from a factual perspective, as we've seen from what Hazel has said, and a legal perspective, but it's quite easy to get wrapped up in that. And as James said, that would maybe be to miss the opportunity to reflect on broader lessons, because the reality is, it's very likely that circumstances akin to Morrisons would give rise to direct liability for employers and controllers. And of course, it's very unlikely that even if you didn't have direct liability, you would have a profile quite like that of Mr. Skelton, someone who was hell-bent on ruining the organisation. It's much more likely that it would be sort of partly accidental action that's led to breach. So what practical steps can employers take? I think there's a lot to get through. There are lots of steps and lots of really good guidance on this, but actually the interesting thing is that they're relatively similar regardless of the underlying circumstances relating to the insider threat. So to explain that a little more, I guess the starting point is that insider threats are easily overlooked, but organizations should remember that they are at least as dangerous, and none more obviously than Mr. Skelton, as the black hat hacker or another third party actor. Having said that, the insider threat doesn't just relate to the jilted employee or the Morrisons threat, but there's a broader set of risks emanating from the problem in chair, not in computer, or the picnic. So typically that captures staff members who unintentionally cause damage by clicking on the phishing scam link or accidentally publishing payroll data on a public-facing file sharing site. And as well, less commonly, those staff members who are motivated to damage. And while never appear, we think that employers can and should take a number of steps, and we've outlined a few of them. So let's try and get through some of them now. The first one I've outlined is DD, or due diligence. So background checks should be carried out on candidates as probably as the last part of your recruitment process. So what's appropriate in terms of a check will depend on the circumstances and the role. And obviously it's important to get the balance right between the applicant's privacy rights and the employer's interests. But a basic level of CV verification and reference checking should be carried out for all as a condition of any offer of employment. Other steps here might include incorporating interview questions or situational analysis specific to information security for some particular roles, high-risk roles, like those in legal, information security, HR, perhaps customer relationship. Onboarding, so beyond the recruitment part, onboarding is a really crucial but often overlooked opportunity to be clear from the start about expectations when it comes to data protection and information security. So induction processes should include overviews of relevant policies, new starter training, focusing on the importance of speaking up when it comes to malpractice, and how to identify and report a potential breach. And as I mentioned before, it's also really important that you scope the role properly. You've got clear job descriptions and clarity on the scope of authority, so that you can say, if worst comes to worst, they were acting beyond authority and perhaps not in their field of activities, getting back to the test. The next point is around access. Many employers, I think in our experience, set greatly restricted access to information generally, more often fail to update it as the circumstances of employment move on. To explain that a little further, a really key function of those who are responsible for cyber or information security in your organisation should be to set access to the platforms that you have and which contain personal data, so mailboxes, customer relationship management, HR platforms, and similar. Those should be set per function and role on a kind of genuine need-to-know basis. They should also be reviewed on particular milestones. So obviously access should be revoked on termination, changed on promotion and demotion, and again revisited as the organization adopts new platforms and new ways of processing information. And of course, they should be periodically reviewed more generally. The next thing I would say is, and if you take one thing away from today, it's this: two-factor authentication in terms of accessing platforms and systems is as close to a silver bullet as we see in practice when we're dealing with data breaches. So having it in place for platforms and systems, I think, should be priority number one, if that's not already the case. That should be, of course, accompanied by automated logging of access to systems and platforms so that users accessing at critical times can be identified if that's necessary. One measure that Morrisons did have in place, and something that Hazel touched on, and I think possibly would be criticised for if it happened now, is blocking of USB ports. So preventing the exporting of information to kind of physical storage locations like external hard drives and USB sticks is a achievable and recommended step here. Of course, beyond that, it's important to make sure that devices you do use or which are sanctioned or encrypted or allow for encryption of data in transfer and at rest. Then beyond that, physical measures, again, something that's easily overlooked because we all strain, I think, for paperless workplaces. In my experience, that's rarely the reality when it comes to information storage. There's usually something physical, and it usually gives rise to concerns about how it's stored. So the key mitigations here probably include controlling access to premises by secure card, fingerprint, iris scanning, bearing in mind your obligations when it comes to that particular special category data, or another method that's logged and accessible. Having and enforcing, importantly, clear desk policies and providing a means for that, so lockable cabinets. And then other measures we come across are CCTV in common areas, additional security for high-risk areas, and access to confidential shredding facilities, probably avoiding James's particular vendor that failed to get rid of that particular piece of equipment. Next slide. We come on then to lawyers' favourite topics, which is policies. I think lawyers can sometimes be fairly accused of using policies as an answer to everything, but in this particular instance, having clear and comprehensive rules and guidance on expected behaviours can importantly avoid harmful breaches altogether, but they can also be key in helping to absolve employers of responsibility, both legally and sometimes even in the court of public opinion, which can be important, especially if those policies are backed up by other steps like training. So I've listed some of the key or expected policies that we would like to see dealing with information security and data protection. I think the important themes are that they must provide clear guidance about how they should help the employer to protect data, how information is to be accessed and used, guidance on passwords, on sharing of information, procedures for spotting concerning or suspicious activity, procedures for reporting potential breaches like lost laptops, wrong recipients, use of unsecured file sharing platforms, and actually something that's quite often lost is a description of what a breach is. So it's not always clear to the audience that something that appears as innocuous as a file left on a train can amount to a data breach, a reportable data breach. Of course, the kind of centerpiece is the breach or the incident response plan, and that should set out who's responsible for responding, how the breach team can be contacted, how the data can be recovered or the breach mitigated, and what the company will do in terms of communicating with regulators, with clients or customers, and with other employees, and even how they might deal with media coverage, which is on the rise in terms of these incidents. Morrisons actually did have an incident response plan. They reacted quickly and they spent quite a lot of money to try and rectify the damage here. And that seems to have played in their favour in some respects. Finally, on policies, the consequences of breaching policies need to be clear. It's never nice to say in paper, to commit to paper, that you might be dismissed for a breach of the policy, but that's the reality of the world we live in. And if you don't say it, you can expect pushback from employees. And then I suppose the other thing to say is that policies are ideally layered so that they're accessible. So vital messages up front, they're clearly and concisely communicated, and maybe some further detail that sits behind it if necessary. I've got training here too, another kind of comfortable domain for lawyers, but it is true that all staff should have at least a level of kind of mandatory data protection and information security testing. They should be able to identify particular risks around data, including the hallmarks of a phishing scam and the appropriate and approved way to share data. Beyond that, it's important to have more in-depth and tailored training for two further categories. So the first one, those who have routine access to personal data and might be described as high risk. And again, I'd refer typically to IT teams, HR functions, payroll, sales, customer relationship management. And secondly, those who, of course, form part of your breach or incident response team. It goes without saying that that training should be repeated regularly and should seek to engage people rather than tick boxes, as it were. So of course, there's a role for pre-recorded videos in big organizations, but you'll see that the best return on investment when it comes to training is often smaller group discussions, simulated breaches, testing and kind of discussion type forums, or at least that's what we see. And the final practical step I've got here is monitoring. So of course, employers should have systems in place to monitor network traffic, to identify suspicious activity, and to flag down risks. This is an information security professional's domain, but of course, you'd expect to see kind of network and host intrusion detection systems, malware protection software, and other data loss prevention tools. So there are a range on the market. Many of them help to detect, as well as cyber attacks, they help to detect the insider threats. So they help to ward off emails that are about to go to an unrecognized recipient or which are about to be dispatched with large attachments that don't seem to fit. And the machine learning in that particular world is impressive and helpful. Of course, there's also a kind of bigger market for mobile device management tools, and again, they help to kind of block, log, remotely access and wipe facilities where workers are working remotely, which is increasingly, of course, the reality we live in. Just before I move on, I would just point one thing out. It's really important not to see monitoring tech as the silver bullet or the complete answer, because of course, on the other side of the coin, employers can land themselves in trouble if those aren't deployed appropriately. Employees have a right to privacy in their workplace communications, and you have to justify and make sure any interference is proportionate. So that's the starting point, and some more detailed analysis is needed before rushing to invest in that. So moving to the final slide, I did just want to put a quick flag in the ground that there are, of course, increased risk factors at the moment, given the reality of the world we're living in, a remote workforce for many. So there's four particular risks to be live to, I think. So there's a spike in opportunistic actors. So Google reported a 350% increase in phishing attacks. But of course, what phishing attacks often need is someone, i.e. a staff member, to respond to them. And unfortunately, a common theme around COVID-19 is phishing, spear phishing, and whaling attacks, where scammers pose as public health authorities, HMRC, banks, senior managers, or directors, and who seem to be reaching out helpfully. It doesn't bear thinking about, but it exists. Of course, that's compounded by the fact that we have less control over employees when they're not physically present, and that our information security functions, if we have them, are focusing on other challenges. But some practicals there are a quick reminder to employees about the threats, what they look like, how they can identify them, and importantly, how they can report them when they see them. And of course, making sure employees have a secure and password protected Wi-Fi access at home. No one hopefully is logging in at a cafe for many reasons at the moment, but that kind of thing is kind of rife. The remote working environment is another issue here. I think the really important thing here is that, again, it's important to communicate on practical do's and don'ts, so taking calls in separate rooms to housemates, not leaving papers around, etc. I've listed employee morale as a factor. That's almost a whole different kind of discussion, but of course it's important to be live to the fact that employees might be disenchanted, they might be frustrated, they might just feel more detached, and that increases the risk profile. And there's no substitute for managers staying in contact as the remedy for that. And finally, from me, communication and document sharing. So of course, we're harnessing lots of new collaboration tools, and that's important and good, but there is a lot of pressure on remote working environments and on virtual private networks. There will be service interruptions. You will have experienced slow response times, and that in turn makes it very tempting to try and work off network by hiving out important spreadsheets to Gmail, for example. It's just a bad idea, and employees should be, of course, reminded of that. So I really, as I've said before, really highly recommend the starting point two-factor authentication on network working only, and clear communication around what's expected, especially in the circumstances. So I hope that's helpful, albeit quite a quick run through, and I'll hand over to Hazel.
Okay, thank you very much, David. That was very comprehensive. I'm just looking that we don't at the moment have any questions because James and David, you are so beautifully clear. But this gives me an opportunity to ask a couple of questions myself, which I will grasp with both hands. So James, I'm going to turn to you first of all and say, where do you think this leaves privacy litigation in, say, 1 or 2 years' time? What are we going to see? Get your crystal ball out. Give me a prediction.
Yeah, I think it's probably worth saying at the outset, in case people are wondering, that despite COVID-19, things haven't stopped. The courts are dealing with the disruption in a commendably sophisticated way, and I've been attending video hearings and video mediations and all sorts, and things are running, even if it's not quite business as usual. In terms of where we go, I mean, plainly the thing on everyone's minds is Lloyd and Google. That's on its way to the Supreme Court. It was probably going to be tipping the end of this year into next in any event without the coronavirus. It's, I think, inescapable now that we won't have an outcome, at least until probably the middle of 2021. But it will tell us a lot. Privacy litigation is a little stuck in England at the moment, and one of the advantages for claimants is there's relatively little jurisprudence. In particular, there's not much case law on what damages people are entitled to, and some of our listeners will be very familiar with demands for enormous sums that don't seem to bear any relation to the harm, if any, that has been caused to someone, whether it's by being 2 days late deleting their data or through some sort of data breach. And I think we can hope to hear a little bit more on damages through the Supreme Court, certainly some of the principles, and that will help enormously. It might mean that businesses feel they have a little bit more of a choice than to settle matters simply for their nuisance value. Otherwise, I think one of the areas that hasn't really hit the headlines yet, but inevitably will do as the GDPR framework matures, is the sort of apportionment of liability that is envisaged by Article 82, where, as you'll know all too well, Hazel, controllers and processors might be jointly on the hook, but a claimant can effectively go and enforce their desires and the litigation, their claim against whoever's got the deepest pockets, and then it's for the controller and processor to sort out the mess afterwards. And I think we will start to see some disputes in that area as well. So watch this space, both in terms of the prospects for these big collective actions, the shape of litigation in general, with that dynamic caused by the uncertainty over damages, etc., and a growing move towards a sort of a groundswell of business-to-business disputes as controllers get a little bit more assertive against processors who have let them down, and quite potentially vice versa as well.
Yeah, that's a very good point. That's quite a big bun fight waiting to happen, I think, the controller/processor situation.
Yeah.
David, I'm interested because I think certainly in this current environment, there will be a lot of employers who say, I don't have limitless funds right now, and clearly this is a risk that I need to deal with. It's a lot to cover, and it's a lot to pay for. So David, what would you recommend as 2 or 3 things that you either think are essential or, I don't know, potentially of limited cost to employers that they really should focus their energies and resources on in order to mitigate this insider threat risk?
Sure, thanks, Hazel. I think actually probably my top 3 are the most affordable steps, and in fact the things that many organizations can do themselves. So I suppose the first one is scope your roles properly, be clear about what authority staff members have, and be clear about what the expectations are on them when you onboard them. So you get the relationship off to a start where you explain how important information security is. Secondly, the kind of golden ticket or almost golden ticket, the 2-factor authentication when it comes to access to online systems. And in tandem with that, reviewing what access you have, revoking access very quickly when you terminate people.
Okay.
Again, that's something you can do for free. And I think the final thing, and this is kind of COVID specific, but get your policies and communications right. Make sure they reflect the way you're now working, and be in active communication with people about what they should and shouldn't do when they're working remotely.
Okay, thank you. That's a very cost-effective way for employers to make the best of the situation. So thank you both, David and James, for some really great explanations and tips. I hope everybody listening in, you've enjoyed this session. We will be following up with a copy of the recording and the slides. Please do let us know if you have any specific topics that you would like us to touch on in the future. I think for me, the key aspects are, I feel that Morrisons were both lucky and unlucky. Unlucky in that they had to get all the way to the Supreme Court to avoid vicarious liability, but lucky, in my view, to avoid that direct liability for breach of the requirement for appropriate security. So please, 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 don't forget the requirement for appropriate security. Don't forget that direct liability. James's calculation on the potential risk for collective actions and how that aggregate collection of claims can outweigh the GDPR fines seemed to me to be a really relevant point for us all to bear in mind as to where things might end up. And David, thank you so much for the practical tips on the really sensible things that you can do that are low cost but can really limit the risk to an employer. So thank you all very much for joining us. That's the end of this webinar, and we look forward to seeing you or speaking with you on another one soon. Thanks, Em.